Hello, my name is Dr. Christian Mammen. Today I'm going to be discussing the relationship between intellectual property law and creativity in the context of generative AI. This presentation grows out of a white paper prepared in the summer of 2024 by a multidisciplinary group of Oxford scholars that I brought together while on sabbatical at the Oxford University Faculty of Law. This presentation is divided into three parts. First, we will review the legal authorities establishing that authors and inventors must be human under copyright and patent law. Second, we will examine the extent to which this requirement is tied to concepts of creativity. Third, we will take a deeper dive into the concept of creativity, examining which aspects matter to IP law and how generative AI measures up. So let's turn to the human authorship requirement. We will start with copyright law. There are a variety of copyright issues arising out of the black box of generative AI. Some relate to inputs, for example, as training data, shown here on the left. Some relate to outputs of the generative AI tools, shown here on the right and highlighted in blue. We will be focusing here on the outputs. The application of copyright law to generative AI raises a wide variety of questions, some of which are listed here. They include the authorship question, whether AI outputs are copyrightable, questions about the training data, and the use of AI technology in connection with copyright enforcement. We are going to focus on the first of these questions. Our starting point is the U.S. Constitution Patent and Copyright Clause, which specifically states that it is securing for limited times to authors and inventors the exclusive rights to their respective writings and discoveries. This is echoed then in the Copyright Act, which provides for protecting original works of authorship and determinations that author is implicitly required to be a natural person. Dating back to the 19th century, there are multiple decisions from the U.S. Supreme Court emphasizing the human creative aspect of copyright protection. In trademark cases from 1879 talks about the creative powers of the mind. And the Burrough-Giles case also emphasizes that even in the case of photographs, there is a human creative element that is worthy of protection. In 1884, there was a dispute that arose over copies of this photo of Oscar Wilde that were being sold as lithographic trading cards, if you will. And the argument was that a photograph, because it just captures a representation of reality, is not copyrightable. And the Supreme Court held that there are a number of creative inputs that support the finding that, in fact, photographs are copyrightable. Flashing forward a little over 100 years, the Copyright Office has repeatedly emphasized in its compendium that a human author is required and that authorship under the Copyright Act refers only to humans. Around that same time, there was a case involving the now famous monkey selfie. And in that case, the Ninth Circuit ultimately ruled that only humans have statutory standing under the Copyright Act, and that the terms of the statute do require that authors be humans under that act. This has continued to be re-emphasized in the 2021 third compendium of the Copyright Office, hearkening back to those 19th century cases and emphasizing again that the author must be a human. This was further emphasized in 2023 when the Copyright Office issued some guidance concerning policies relating to generative AI. And the upshot of that presentation is that merely typing a prompt into a generative AI tool is insufficient creative input in order to qualify the prompt engineer or human using the AI tool to be named as an author. That's based on present understandings of present implementations of generative AI tools and may be subject to change in the future, but is the current policy of the Copyright Office. Much of the current discussion about AI authorship has been driven by Professor Stephen Thaler and his AI tool, Dabus. In the copyright sphere, Dabus has been tasked with generating a number of images, including this image called A Recent Entrance to Paradise. Dr. Thaler applied for copyright registration and specifically said he had no involvement in writing prompts or generating the image. In 2022, the Copyright Office confirmed that because there is no human artist, the image cannot be registered. This was confirmed by the District Court in the District of Columbia in 2023, and the case is currently on appeal to the U.S. Court of Appeals for the D.C. Circuit. Other sample cases from the last year or two include a graphic novel called Zarya of the Dawn. Initially, this graphic novel was allowed a copyright registration, but then based on publicly available information that came to light indicating that the images were generated by an AI tool, the Copyright Office revoked the registration, and following further proceedings, it was determined that the images alone were not copyrightable. The text, which was human authored, was copyrightable, and that the combination, that is the arrangement of images, the selection and placement of text, and the overall package were also copyrightable. Another example is this image titled Théâtre d'Opéra Spécial, created by Jason Allen, and this image won a prize at the Colorado State Fair. Nonetheless, the Copyright Office declined registration because it was created in significant part using Midjourney. Following the creation of the Midjourney image, Mr. Allen did make a number of additional edits and changes to the image to enhance it. However, during the registration process, he refused to disclaim the portions of the image that were created by the AI and consequently to claim only the creative contributions that he added. And because of that refusal, the image was not given a copyright registration. As we look at these generative AI issues in 2022, 2023, and 2024, it's worth rewinding a bit to consider that in the UK, there has been a provision on the books in the Copyright Act since 1988, providing that computer-generated works are given a special limited period of copyright for 50 years. This is less than human-generated copyrights, but it is more than being completely uncopyrightable. Curiously, the provision says that the author of the computer-generated work shall be taken to be the person by whom the arrangements necessary for the creation of the work are undertaken. It remains unclear and unresolved in the courts whether that refers to the prompt engineer, the programmer, or somebody else entirely. To date, we're unaware of this provision being tested in the age of generative AI. In an effort to understand why the UK Parliament might have been motivated in the late 1980s to enact such a law, one clue comes from a 1985 article by Professor Pam Samuelson titled Allocating Ownership in Computer-Generated Works. And so this issue has been bouncing around in academic discussions and elsewhere for 40 years. And many of the same questions that we're currently considering are ones that were addressed in articles such as Professor Samuelson's article. She suggests considering 5 different ownership allocation possibilities, and ultimately concludes that the user of a computer system should be deemed the author. Now, generative AI had not come to the fore yet, and so Professor Samuelson's article includes a number of assumptions about the way computer technology would evolve. Some of those hold up after 40 years, and some don't. So it's certainly an interesting part of the continuity of the current debate. Let's turn now to patent law. Questions surrounding AI in patent law are divisible into 3 significant buckets. One is where the AI itself is the invention. One is where the AI is the inventor. And the third is where the AI helps the human inventor. The first of these face a number of questions, including patentable subject matter, disclosure, where the AI is a black box, and where the fully trained data model is continually evolving. It's difficult to discuss the scope of what is ultimately claimed if the claim is on the trained data model as including the training data. Where the AI helps the human inventor, we consider it in terms of other research tools or technology tools that help humans conduct inventions. We're going to focus on the middle one of these, where the AI is alleged to be the inventor. Again, our starting point is the Patent and Copyright Clause of the U.S. Constitution, and also provisions of the Patent Act, which identify an inventor as an individual who invented or discovered the subject matter of the invention, and also refers to the inventor as whoever invents and a person. Again, Professor Stephen Thaler, in connection with the Artificial Inventor Project, tasked Dabus with coming up with inventions, and there were 2 in particular that Dabus created and that the Artificial Inventor Project filed patent applications on around the world. One is a fractal container, and the other is a neural flame. This is an image from the patent application on the fractal container. When these applications first became public and came on the scene in the fall of 2019, the US Patent Office, the UK Patent Office, and the European Patent Office all indicated that Dabus could not be a named inventor. The reasoning behind these decisions were variously that statutes and case law required inventors to be human. Particularly in the case of the UK, there was a failure to satisfy certain formalities in the statutes. And also, to a certain extent, that the act of invention requires a theory of mind that was not extendable to AI algorithms. As a consequence, in 2019, the UK Intellectual Property Office revised its formalities manual to indicate that an AI inventor is not acceptable because it does not identify a person as required by law. Flash forward about 2 years from then, and there were 2 cases where Dabus was allowed to be named as an inventor on patents. One was in South Africa, and the other one was at an Australian trial court. We'll take a quick look at both of those. In South Africa, inventor is not defined in the statute. Moreover, patents in South Africa are not subject to examination, but are rather subject to registration, much as copyrights and trademarks are. In Australia, while inventor is defined as a person, the trial court made a number of assumptions about the capabilities of the AI in concluding that it could be named as an inventor. And in particular, it assumed that the AI set and defined its own goals, assumed that the AI had free choice in choosing between various options and pathways, assumed that the AI provided and selected its own input data, and assumed further that these are the kinds of choices that Dabus made in coming up with the 2 inventions in the patent applications we've discussed. This decision was reversed by the Australian Court of Appeals. The Court of Appeals focused on the patent bargain, that is the exchange of patent rights as an incentive to inventors to create and disclose inventions, further construed inventor to be a person, which means a natural person because of the requirement of a theory of mind, but did suggest that Thaler could own Dabus's output. And we'll get back to that in relation to the UK decisions, where the opposite conclusion was reached. Meanwhile, in the US, the Patent Office decisions made their way through the courts, and the US Court of Appeals for the Federal Circuit ruled that Dabus cannot be an inventor under US patent law because an individual means a human being, citing a variety of sources. The Supreme Court denied review in April of 2023, so this is the final decision of the US courts. In the UK, the Court of Appeal reached a decision in 2021, and it was a split decision, 2-1. There were several questions considered. The first one was whether Dabus could be named as an inventor. And all 3 judges on the Court of Appeals held that no, persons under the UK Act requires natural or legal persons to be inventors, and that an AI could not be a named inventor. However, under the formalities of the UK Patent Act, the applicant doesn't have to name an inventor. It either has to name the inventor, or the applicant has to explain how he or she obtained the right to apply for the invention. And in that context, the third question, which is where the Court of Appeals judges split, is whether Dr. Thaler, as the creator of the Davos AI, had a right to apply for the patents. And in addition to the fact that he filled out the forms improperly by naming a non-person as the inventor, the majority also rejected his argument based on the doctrine of accession as articulated by Blackstone. The doctrine of accession holds briefly that if I own property and there's a tree growing on the property and the tree produces apples, I own the apples because I own the land. The court held that that doesn't apply to intangibles like AI inventions or outputs of computer programs, but only applies to tangible things like apples. The third question was whether Dr. Thaler's application was deemed withdrawn because he had failed to fix these problems. The Supreme Court, in a unanimous decision at the end of 2023, affirmed the Court of Appeal, holding that only humans can be inventors, and the applicant does not have to name an inventor, but only within these narrow statutory exceptions, and furthermore affirmed the Court of Appeals analysis of Blackstone and the doctrine of accession. So therefore, coming forward another couple of years, as of late 2023, everywhere that has ruled on the issue has held that Davos cannot be named an inventor except South Africa. This leads to a further question about the relationship between human inventors and AI-enabled research. And in 2024, the U.S. Patent Office issued some guidelines on this question, reaffirming that inventors and joint inventors must be natural persons, that an AI cannot be considered a co-inventor or joint inventor with a human, and concluded that the human inventor is subject to the existing standards for being named a joint inventor under the standards set forth in the Panu versus IOLAB case. And as long as there's one human who can be named as a joint inventor under the Panu factors, there is sufficient human inventorship. Let's turn now to the second question, the importance of human creativity to IP protection. So the question here is whether human creativity, with its inputs and outputs, namely reading books, thinking about things, and then coming up with new images, music, text, or whatever, is that just like what happens in the case of AI? Returning to our baseline of the constitutional IP clause, we note that the courts have held that this clause is intended to motivate creative activity by provision of a special reward. In copyright, as we've seen, there are a number of different rulings holding that authorship depends on the exercise of creativity. This bar is low. Copyright Office itself says it's a minimal degree of creativity. In the Feist case, which has to do with telephone books, there is an explanation that the creative spark must exist, no matter how crude, humble, or obvious it might be. And examples of that include the Bleistein case, which had to do with the copyrightability of circus posters in an opinion by Justice Oliver Wendell Holmes. This bar truly is low. Examples include photographs, such as the Burrough-Giles case, as well as human-edited and arranged versions of words received via dictation from celestial beings or a voice. There are multiple cases in which humans purport to have received these kinds of dictations from non-human sources and to have not only written them down, but edited and arranged them. And that editing and arranging provides a basis for copyrightability. By contrast, things not found copyrightable include gardens, a phone book, the monkey selfie, and straight transcripts of messages received from spirit beings. Here is some further detail about some of the cases reflecting these copyrightability questions. Patents as well involve an exercise of creativity. Courts have talked about the creative genius involved, and in particular that flash of genius, that creative spark, the proverbial light bulb going on. That said, it is also recognized that there's not only that flash of genius that will support creativity for patentability, but also systemic experimentation, so long as the systemic experimentation is not a path that is obvious to try. One thing that's particularly interesting here is that the question of creativity in the patent context is not tied to the definition of inventor or to the issue of inventorship, but is rather tied to non-obviousness, as that's set forth in 35 U.S.C. Section 103. This creativity, as I indicated, is indicated as the spark of genius or the result of systemic experimentation as viewed from the standpoint of a person of ordinary skill in the art at the time of the invention. So we can have a human inventor and separately analyze whether or not the human has engaged in sufficient creativity to result in a patentable invention. So let's turn now to our third section. What is it about creativity that matters to IP law? There are, it turns out, several different components of creativity. The one that we are frequently used to talking about is what is referred in the scholarship as external creativity. That is an assessment of the artifact, the thing. Is it creative? Standard definitions of external creativity include that it is new, it is valuable, and it is surprising. And this is most commonly the component of creativity that comes to mind when we talk about whether or not AI-generated artifacts are creative. They're qualitatively perhaps just as good as human-made artifacts, and they may be comparably new, comparably valuable, and comparably surprising, arguably, to human-made artifacts that are protectable. But there's a second component as well of creativity, the psychological or internal component of creativity. And theoretical accounts of the psychological aspect of creativity, as well as the neuroscience of creativity, focus on three components as being particularly important. First is what's referred to as convergent thinking or task-positive thinking. And this is typically associated with the central executive network of the human brain. The second is divergent thinking, sometimes referred to as daydreaming or free association or unfocused thinking. And this is typically associated with the default mode network of the brain. And the third component is the salience network, which is the ability to recognize that some idea is salient, is connected to, relevant to some other thing. And the generalized accounts of creativity from both a theoretical point of view and a psychological neuroscientific point of view indicate that creativity involves something of a dance between these three components. Convergent thinking is task-focused, trying to solve a problem, working on something. The divergent thinking comes about where freed of the task focus, brain is free to wander unrestricted. So we think of this typically as being, you work on a project, you're trying to solve a project, you get stumped, you go for a walk, or you sleep on it, or ideas come to you in the shower. That's an example of divergent thinking occurring. Something happens with the salience network, the light bulb comes on, and it provides a solution to the task-positive convergent thinking. And this process, as we'll see, is particularly important and connected with the creativity of the external artifacts. And then the third one that we identified and described in more detail in our white paper is the societal or community aspect of creativity. To say something is new depends on a frame of reference. To whom is it new? For example, if we talk about the creativity of a young child who's drawing pictures with crayons, the picture may be new to them and in that sense is narrowly creative without necessarily being new to society as a whole. We can call that creative without having some standard of it being completely new and unheard of in society. The question of whether something is valuable is social. It has to be valued by the community. And salience or relevance also has elements of social evaluation. So let's illustrate in a couple of different ways this social or community aspect of creativity. On the left, there's a Venn diagram that depicts one circle showing originality and a number of descriptors relating to the idea of originality. And on the right is a circle showing appropriateness, usefulness, suitability, relevance, value, adaptivity. And these are all elements of the social context. And it's only where that originality and appropriateness overlap that we find creativity. On the right-hand part of the slide is a graph illustrating another feature of this social aspect of creativity. The x-axis shows a range from familiar outputs to things that are really, really new. And the y-axis shows at the 0 point indifference to something. The positive y values show positive hedonic value, people like it. And negative hedonic value, people don't like it. And the idea that's shown here is that if you start with something very familiar, routine, people tend to be indifferent to it. And if you move a little bit out into the novelty range, then things start moving in the positive direction for hedonic value. But at some point, they get too new, too different, too unfamiliar, and the hedonic value starts dropping. And ultimately, if it gets too far out, too avant-garde, then people don't like it. It creates a negative hedonic value. So let's take these concepts and apply them to what we've learned about intellectual property law's creativity requirements. First, with copyright. To be sure, we must have an expression in a tangible form. We have to have an artifact to be copyrightable. However, how creative it is, that is, how new, how valuable, how surprising it is not something that the Copyright Office finds itself in the business of addressing. We don't judge how good it is, just that it has some creativity. How do we measure that creativity? It has to be the product of internal psychological creativity. It must be the fruit of intellectual labor founded in the creative powers of the mind. It's a low threshold, but it is there. And in terms of social factors, because we don't judge the quality of the creativity, it's less relevant unless the artifact is copied within the definition of copying under the Copyright Act. Turning to patent, again, we have to have an external exercise of creativity. There has to be a reduction to practice, whether it's actual or constructive. And the invention must be new, useful, and non-obvious. Those have their clear parallels in the creativity scholarship's requirements of novelty, value, and surprisingness. The internal aspect of creativity is also required, as we saw, either as a flash of genius or as methodical but non-obvious, not obvious to try research. And the social factors in patent law show up as the measure of the level of skill in the relevant art at the time of the invention. You'll see that under both of these, neither account of creativity in copyright or patent law goes into detail about the convergent, divergent, and salient aspects of internal psychological creativity. Now let's look at the same rubric of creativity and generative artificial intelligence. As we've discussed, there's this question of artifacts that come out of generative AI being often assessed along the same guidelines as human output, saying, gosh, this is just as good as human output. That's apparently true for novelty, though there is a question about whether generative AI, because it's based on a probability model, whether that probability model is more deterministic than the novelty of human outputs. Value is apparently judged on more or less the same scale as human outputs. But surprisingness may well be different on generative AI. Partly it's because the um, probabilistic determinations of generative AI models mean that the more preferred outcomes, particularly when the settings of the generative AI are set to be more deterministic and less chaotic, will be less surprising. They'll be more familiar. By the same token, there are some aspects of salience filtering in human outputs that are not present with generative AI. And so occasionally we do end up with some surprising things with AI outputs. Sometimes, those are not deemed good, such as, pictures of people with 8 fingers on one hand or 87 teeth. In terms of the internal aspect of creativity for generative artificial intelligence, we have an indeterminate and perhaps mixed conclusions. While convergent thinking may well have analogs in the task focus aspect of algorithmic outputs, we are presently unable to articulate any analogs to divergent thinking. One attempted analog may be sort of the brute force computation through hundreds or millions of permutations, but that's really different from divergent thinking as we understand it. As to salience, it's not really present, particularly in the age of prompt-started generative AI. The salience, the relevant filters are determined by the prompt that's entered by the prompt engineer, as well as by any filters that are or guardrails that are established by the AI platform. In terms of social factors, we have a variety of observations there as well. Some artifacts are regarded as though they are human-made. Some are comfortingly familiar, even if they are derivative or seen as derivative. But we have a vocabulary to talk about things where things are just a little bit off in the AI outputs. We talk about the uncanny valley. We also talk about things being too weird. And so think back to the graphs that I showed you in terms of the social aspects of creativity. And because of this, we reach the conclusion that the internal aspect of creativity, which is important to both copyright law and patent law, cannot be clearly shown to be present in generative AI outputs or in the generative AI process. And for that reason, it's not sufficient to say AI outputs are just as good as human outputs and therefore deserving of IP protection. We have to develop an account of internal psychological creativity before generative AI should be allowed to be identified as authors or inventors. I wanted to close with one observation about this distinction. There's been a lot of research published in 2024 about how AI trained on AI-generated data, that is synthetic data that's fed back into an AI system as training data, can lead to collapse of the AI model. And one of the illustrations that's given is if we start with a set of images of popular breeds of dogs, and we'll notice that golden retrievers are a popular kind of dog, and so they tend to be slightly more represented in the original natural data set. And if we ask the AI to generate an image of a dog, it's likely to somewhat overrepresent the golden retriever in its output set. There's going to be slightly more golden retrievers in its output set because it favors the thick part of the bell curve. And if we do that again and again and again, at some point, we'll end up with an output 7, 8, 9, 20 generations later that's all golden retrievers. And then, strangely, the researchers have shown that once that happens, then the model starts to lose track of some of the other structural aspects of the images or texts or whatever it is that it's tracking. And so instead of golden retrievers, it starts to generate sort of chocolate chip cookie licking blobs or some other kind of incoherent output. And so what this illustrates for us here is that there is something about the nature and distribution of human-created data, human creativity, that is necessary to sustaining AI models, and that if AIs are just retrained on themselves, they will inevitably lead to model collapse. So there's something missing from the AI data that's just not present compared with real world data. If you're interested in hearing further about this analysis, please look up our white paper. It's available on SSRN. There's a link shown here, as well as a QR code that will take you to that link. And with that, I want to thank you for your time and attention. Feel free to reach out to me if you have comments or questions.